What's up, guys? It's the Bad Wolf. Are you guys ready for some more fire information? Of course you are. That's why you guys came. If this is your first time here, don't forget to hit that bell, like, and subscribe. Let's get to it. All right. So, this particular video is about how to present yourself in federal district court, or should I say, represent. All right. Now, remember, the living person is always in the present. So, really, you are presenting yourself, not re-presenting yourself. But the re part comes in at the straw man, because that's the name in which you're doing almost all of your things. Okay. Now, for those people who don't know, keep in mind that the government itself looked at your all capitalized name is actually being you on the government level. But on the state level, the all caps name is in fact the legal person, all right, that you're doing business with. We've already proven this in multiple videos. So, but I digress. As always, don't forget to check out Black Site 32 and be a part of the newsletter group. All right. So if you can join that, I would appreciate that. As always, guys, you can also join me on my backup channel on YouTube, which is the Bad Wolf Media channel. Okay. And if you guys haven't heard in the next couple of months, or weeks or days, I will be taking a hiatus from making videos, at least on this channel. I'm at the point where I have exhausted a majority of the information I can bring to the public side, if you will. And so I will be making some seminars that some will be free and some will be for pay, depending on what they are. Check blacksite32.com for that information. Otherwise, you can use Badwolf Unincorporated or jamesclovett.com. Any of those will get you there. And check out the seminars page so you can see when those are coming out, when you guys might be able to be a part of those, and whichever ones you want to see. So thank you in advance for everybody who's helped promote this channel. We are skyrocketing to 100,000, and you guys are making that happen. So once again, thank each and every one of you guys sincerely, personally, and truly. If you guys see any of my other videos out there and someone's using them in any negative way, bullying, slandering, calling me outside of my name or whatever else, I thank you in advance for using the button over there or down there, depending on what you're looking at, to be able to report them for defamation of character, bullying, and slander. Thank you in advance. All right. Remember, there's even people in this particular industry or niche that want to be against each other for no good reason. And there's a lot of people who are pretending to be one of you, and they're really agents out there. And then some people are just trash, okay, and scamming people out there. So be careful of all that. So even with my information, guys, vet the information, because at the end of the day, what most of these gurus aren't going to tell you is that it's going to be on you to prove your court case, who and what you are, and whatever else. And if the price seems too expensive, don't pay it. Keep looking, okay? Because everything out there you guys can find for free. There's none of us on here that are getting super proprietary information that you have to, do all these weird things to get, and it's high value. It's literally in these books. So don't let anybody fool you. All right. Especially yourself. A lot of times people fool themselves, and that's your worst enemy. All right. So with that being said, once again on Black Site 32 or Bad Wolf Unincorporated, you guys can get a lot of discounts. You guys can get free files. You guys can get free services that the government is providing for you. A lot of those links are on my website. We had 500,000 people come through there. So for all of you people, I don't know why you guys have 500,000 went through my site, but we don't have 500,000 on the YouTube. It's really weird to me because I don't advertise my website. I don't pay for any marketing or any of that. All this is done by you guys, grassroots, word of mouth. So support me on the website, support me here, and if you guys can support you can do monthly donations to the website or on YouTube. You can join the Wolf Pack where you guys can get information behind the scenes on certain videos, commentaries, tips, tricks, and techniques that will make things work a whole lot smoother for you. All right. And that was not rehearsed. All right. That's just how I go. So with that being said, let's get going. I'm going to have the lovely AI read through all of this. Thank you to the people who do listen to this, all the various groups out there that acknowledging me or haven't or whatever else it is. If you're going to use any of my materials, at least throw a shout out to me in your groups and on your YouTube channels or your other platforms. That's all. I just appreciate a little bit of mention goes a long way from a good group or a good person. So thank you for that. All right. One of the things you're going to notice in here is that they're going to use the words like pro se. I personally don't like the word pro se because pro se really means just prosecutor, but you're doing it on your own and you're not really part of their team. I think maybe that's why they separate the word from prosecutor to pro se if you're doing it on your own, because you're not one of them. But the reason why I don't like that word is because then they want to try to hold you for your conduct, penalties, and whatever else on the same level as a prosecutor as one of them. And that's not the correct way to do it from my perspective. So if they let you write up the paperwork the proper way, then I would say go sui juris, meaning of your own free will and accord and from your own jurisdiction. All right. Now, if they throw a hissy fit, then obviously give the baby their bottle, do what you got to do, but it should be sui juris, not pro se. All right. Now, you're also going to notice in here that they're going to throw some things at you, like, trying to scare you. Of course, yes, you should do your best to get everything right. If you think that you have not, maybe you want it reviewed, it's not something I do, so don't bring it my way. But go online and type in either pro bono, which means for free, lawyer or attorney or federal attorney. And you can also go to the American Bar Association's website and look up people who will review your stuff for free. Or once you have everything done, even if you do have to pay a little bit, turn it over to a lawyer or attorney so that they can review it for you to make sure everything is good. Most of the time, if you do it online, you will be fine, okay? Because everything is pretty much already set up. Um, One note I will give you guys when doing your federal lawsuits, keep in mind that um, you want to stay focused. Okay, so stay on the main topic. Don't bring in outside stuff that, even though it happened to you, that might be a separate lawsuit. Okay, some people want to be like, oh well, I don't know who somebody else was doing this over here, and then all this happened. We'll focus in on just where your rights were violated by that particular government agent, police officer, chief of police, tow truck company, hospital worked with you. All of that can be put together as RICO. Okay. If they're using other sources to help do something against you, it's RICO. Go after all of them. But if it's a separate thing, like let's say some guy punched you and then broke your jaw, then police harassed you and did other things, I would say go after that one person for that lawsuit, keep that separate, and even do that on the state level. That's fine. And then over here, do the federal lawsuit against the police officers, the department, or whoever, or whatever it might be, anywhere where they deprive you of your rights during right to travel or whatever else. Now, before you go, if you do want me to help you break down some of your information as far as what violations were done, what you can go after them for, how to put it together a little bit, then we can do a court consult, which is going to be between $500 to $1,000. Right now, it's set at I think 500, but that price may vary or go up depending on the amount of information we have to cover. But of course, I would tell you that in advance. I'm not going to open bill you guys. I don't do that. All right. So so yeah, once again, in here, they're going to try to scare you a little bit to make sure you get everything right. So don't be afraid of any of that. All right. They want you to be sure of what you're doing. And of course, they want to give you the proper information. So they will try to use little scare tactics in their words. Don't let that stop you or hinder you at all, because all you have to do is put it together and have one of the lawyers or attorney or whoever else review it. Once again, that's not what I do. Just to make sure the formatting is right and everything is phrased right, and you got it underneath the right constitutional, law. Um, and then yeah, just submit it. Pay your $400 or whatever it might be in your particular state. Make sure it's the right district court. Um, you can find all that on the federal district court website for your particular state, and then let the magic happen. All right, we've already been successful. We've got about a 90 to 95% success rate going after these guys for violations of your constitutional rights, civil rights in some cases. And yeah, don't be afraid. Let's get going. All right. Thank you for that. All right. Let me see if I can find the so this manual is not exclusive to me by any means. So it is available for free on Badwolf Unincorporated or jamesclovett.com. They're all there. They all go to the same place on the free files page number 2. Now, this is for a particular district, but they're all like 98% identical across the board. All right, but you can find one specifically for your state. So this is to give you an overview, guys. It's going to be a little bit of a longer video, but it will cover all of the things you need to know in basic about doing a federal lawsuit. I get so many people asking me about it and whatever else. So here's the video. I can't say it literally any better than what's in it. So with that being said, let's get going.
Access to Justice Task Force. This is an informational handbook. This handbook is a guide for self-represented litigants. It is not legal advice and should not be considered as such. Do not cite to this handbook in your filings with the court. The court will not consider this handbook as legal authority. Do not contact the clerk's office with questions about this handbook. The court will not answer questions about the handbook's content or how it may pertain to an individual case. Those seeking guidance concerning a federal action should consult with an attorney. Special acknowledgement and appreciation is extended to the United States District Court for the Northern District of New York and the United States District Court for the Northern District of California for permission to adopt portions of their pro-esse litigant handbooks. This handbook may serve as a form for district-specific handbooks. V 2019-2. Introduction. This handbook is designed to help people with filing civil lawsuits in federal court without legal representation. Proceeding without a lawyer is called proceeding pro esse.
Now, what she's really trying to say here is pro se, not pro se or pro c. It's pro se. But that's what I was talking about. So for me, it would be sui juris if I was writing mine up. Now, keep in mind, depending on how they feel when you submit it, if you change pro se to sui juris, they may or may not like that. I haven't heard of anybody really being denied. Um, but that's just my personal feel on that. So, but you guys do what's best for you and what you need to do to get the work done. Okay.
Esse, a Latin phrase meaning for oneself. Representing yourself in a lawsuit can be complicated, time-consuming, and costly. Failing to follow court procedures can mean losing your case. For these reasons, you are urged to work with a lawyer if possible. Do not rely entirely on this handbook. This handbook is meant to be used for informational purposes only and does not constitute legal advice. This handbook provides a summary of civil lawsuit procedures and may not cover all procedures that may apply in your case. It also does not teach you about the laws that will control your case. Make sure you read the applicable federal and local court rules and do your own research at a law library or online to understand your case. This handbook identifies the location of resources you can access, free of charge, to do research. The United States District Court Clerk's Office staff can answer general questions, but they cannot give you any legal advice. For example, they cannot help you decide what to do in your lawsuit, tell you what the law means, or even advise you when documents are due. Warning to incarcerated or detained persons. Please note that some parts of this handbook will not apply to actions filed by incarcerated or detained persons. Detained litigants are often required to comply with different statutes and court rules. These rules may include, but are not limited to, the use of court-approved forms where applicable and the exhaustion of administrative remedies prior to filing suit. 2. Tips for pro se litigants. There is a lot to learn in representing yourself in federal court, but here are some key pointers. 1. Read everything you get from the court and the other side right away, including the papers you get from the clerk's office when you file. It is very important that you know what is going on in your case and what deadlines have been set. 2. Meet every deadline. If you do not know exactly how to do something, try to get help and do your best. It is more important to file/submit required documents and responses on time than to do everything perfectly. You can lose your case if you miss deadlines. If you need more time to do something, ask the court in writing for more time as soon as you know that you will need more time and before the deadline has passed. 3. Use your own words and be as clear as possible. You do not need to try to sound like a lawyer. In the documents you file with the court, be specific about the facts that are important to the lawsuit. When you cite a case that you believe supports your position, explain to the court why that case applies or is similar to your case. 4. Always keep all of your paperwork and stay organized. Keep paper or electronic copies of everything you send to and/or file with the court. Also, keep everything you receive from the court, the other side, or anyone else relating to your case. When you file a paper in the clerk's office, bring at least the original and 2 copies so that you can keep a stamped copy for yourself. Know where your papers are located so that you can use them to work on your case. 5. Have someone else read your papers before you submit/file them. Be sure that person understands what you wrote. If not, rewrite your papers to try to explain yourself more clearly. The judge may not hear you explain yourself in person and may rely only on your papers when making decisions about your case. 3. 6. Be sure the court always has your correct address and phone number. If your contact information changes, contact the clerk's office in writing immediately. Always include your case number on any paperwork that you submit to the court. 7. Omit certain personal identifying information from documents submitted to the court for filing. All documents filed with the court will be available to the public on the internet. Protect your privacy and that of other individuals you refer to in your documents by not including in documents you send to the court any of the following: Social Security and taxpayer identification numbers, names of minor children, dates of birth, and financial account numbers. If your lawsuit involves a minor, you must identify them by their initials only. 7. Check the court's website. Courts will sometimes have a specific web page for esse litigants that includes useful forms and other helpful information specific to that court. 4. Before filing a lawsuit. There are 6 important questions you should consider before you file a case in federal court. This list does not include every important thing to think about. There may be other important considerations that are not listed here. However, these 6 questions are essential to every lawsuit filed in federal court. You should also be aware that even if you can answer yes to each question, and you believe you should win your lawsuit, there is always a possibility that you may not ultimately win. 6 questions to answer. 1. Have I explored alternatives to suing? 2. Have I suffered the type of injury or harm that a court can help me with? 3. Does the federal district court have jurisdiction to hear my claim? 4. Which district is the proper one to file my action? 5. Will my claim be timely if I file it now? 6. Have I exhausted all other available remedies? 1. Have I explored alternatives to suing? Even if you do have the right to sue, you should carefully consider alternatives to suing. Lawsuits can be costly, stressful, and time-consuming. Instead of filing a lawsuit, you can try other alternatives or solutions. Some alternatives to bringing a lawsuit include gathering information. Sometimes things are not what they seem at first. Sometimes things that appear to have been done on purpose were done unintentionally. Fully investigating what happened may help you decide whether a lawsuit is advisable. Working things out. Consider talking directly to the people who you think might be responsible for causing the problem. Sometimes people are more likely to respond in a positive way if they are approached respectfully and given a real opportunity to talk about the problem, rather than if they hear about the problem through a lawsuit. Going to governmental or private agencies. Consider whether there are other processes you could use, or agencies you could ask for help with your problem. Sometimes there is a governmental or private agency that can address your problem or lend assistance to you. Examples of such agencies include the Equal Employment Opportunity Commission, or an equivalent state, county, or city agency, to address employment discrimination. The Local Police Review Board or Office of Citizens' Complaints to hear complaints about police conduct. A Consumer Protection Agency or the local district attorney's office to investigate consumer fraud. The Better Business Bureau or private professional associations, e.g., associations of contractors, accountants, securities dealers, architects and engineers, etc., to hear business-related complaints. Using a small claims court. In some cases, you may have the option of filing a case in small claims court, which is designed for people without formal training in the law. These courts are part of any state court system. There is no equivalent to the small claims court in the federal courts. Alternative dispute resolution. Dispute resolution services, such as mediation, may be faster and less expensive than taking a case to court. Mediation encourages parties to communicate clearly and constructively to find common ground or to identify solutions that can serve the parties' real interests. Many counties have free or low-cost agencies that can assist you in finding a provider of alternative dispute resolution services. Go to page 38 for more information about alternative dispute resolution. 2. Have I suffered the type of injury or harm that a court can help me with? You cannot sue someone just because you are angry at him or her, nor can you sue someone simply because he or she has committed some illegal act. In order to bring a lawsuit that the court will not dismiss right away, the person you are suing must have caused you to be harmed or 6. The person bringing the lawsuit, called the plaintiff, must be asserting his or her own personal legal interests. Typically, a person may not sue to assert the rights of a third party. In other words, a plaintiff normally must assert that he or she has suffered the injury, or that a distinct group of individuals of which he or she is a part has suffered the injury. A court generally will not address a generalized grievance, which is an injury that is shared in substantially equal measure by all or a large class of citizens. One further, the plaintiff must have actually suffered the harm already, or else the plaintiff must be about to suffer the harm imminently, meaning that the plaintiff will actually suffer the harm in the immediate future. Lastly, remember that some cases, such as False Claims Act claims, cannot be handled without an attorney. 1 Worth v. Selden, 422 U.S. 490, 499, 1975, see U.S. v. Hayes, 515 U.S. 737, 743, 1995. 2. It is important to note that in cases invoking diversity jurisdiction with multiple defendants or multiple plaintiffs, no single defendant can be a resident of the same state as any single plaintiff. 4. Those that involve a dispute among residents of different states with an amount in controversy exceeding $75,000.20. 7. If your case does not fall under any of these categories, you should not file it in a federal district court. 4. Which district is the proper one to file my action? If you decide that your claim may be brought in a federal district court because there is either a federal question, the United States is a party, or when the dispute is between residents of different states and the amount in controversy is more than $75,000, you must then determine in which federal court to file. To decide a case, the court you select must have some logical relationship either to the litigants or to the subject matter of the dispute. This is called venue. Generally, you may only file a lawsuit if the actions or inactions that you believe violated your rights occurred within the boundaries of that district court. If you are unsure, call the district court clerk's office for guidance. 5. Will my claim be timely if I file it now? Usually a claim must be filed within a certain period of time after an injury occurs or is discovered. This time bar is called the statute of limitations, and the length of the statute of limitations varies depending on the type of claim. Some federal and state statutes set forth a specific limitations period that may differ from those listed above. Whether your claim is barred by the statute of limitations is a legal question which may require you to do some legal research. You should make sure your claim is not time-barred before you file a lawsuit. 6. Have I exhausted all other available remedies? You should be aware that, in some instances, it is necessary for you to pursue certain remedies before you can properly pursue a claim in federal court. 2 common instances are discussed below. Administrative grievance procedures. 8. People frequently want to appeal the decision of a governmental agency that affects them. For example, a person may want to appeal the decision of the Social Security Administration that denied him or her Social Security benefits. If you want to appeal the denial of a benefit that is provided through an agency of the United States government, you must pursue all the administrative procedures established by the agency for appealing its rulings before you file a lawsuit. Only after you have exhausted your administrative remedies, and you still believe you are entitled to a benefit that you have not received, may you initiate a lawsuit in a federal district court. Employment discrimination claims. A person who believes he or she has been illegally discriminated against by an employer may wish to bring a lawsuit against that employer under Title VII of the Civil Rights Act of 1964, the Americans with Disabilities Act, or the Age Discrimination in Employment Act. However, before a person can bring such a lawsuit, he or she must first file a complaint with either the Equal Employment Opportunity Commission, EEOC, or the State Division of Human Rights. In conclusion, it is important that you consider all of these questions before you file a case. After all of these factors have been considered, you must still follow the procedures set out by the particular district court you decide to file your case. Many of the specific procedural rules for your district court are set forth in the local rules, which are available online or in the clerk's office. Finding an attorney. Bringing a lawsuit can be time-consuming and complicated. While it is possible to navigate the federal judicial system on your own, having an experienced attorney to help you can improve your chances of doing things properly and getting a result with which you are happy. While some lawyers are expensive to hire, there are several options for hiring a lawyer that will cost you little. 9. Or no money. In general, the options are 1. Hiring a lawyer who will work on a contingency basis, 2. Finding a lawyer to take on your case pro bono, meaning at no cost to you, and 3. Asking the court to appoint counsel for you. These options are discussed in more detail below. It is important to note that in a criminal case, a defendant is entitled to legal counsel by the United States Constitution, and one is provided if the criminal defendant is unable to hire a lawyer. However, a party to a civil case is not entitled to an attorney paid for by the government, even if he or she cannot afford one. Counsel performing work on a contingency basis or pro bono. There are several options to find a lawyer to represent you even if you cannot afford to pay for legal services. For example, some attorneys may be willing to accept a reduced fee or lenient fee payment schedule to take on your case. Some attorneys also offer limited representation, meaning that they may help you evaluate your case or draft a pleading, without requiring that you hire them for the entire case. Other attorneys may be willing to accept your case on a contingent fee basis, which means the attorney would receive a fee based upon a percentage of your recovery if you win your case and would receive nothing if you do not win. If you would like assistance in finding an attorney who may consider taking your case on a contingency or limited representation basis, there are lawyer referral services that may be able to help you. For a list of the lawyer referral services located within the federal district you wish to file your claim, check your district court's website. In addition to lawyers who will work for reduced fees or on a contingency basis, many lawyers offer pro bono legal assistance. This means that a lawyer will represent you, but will not charge you any money for their time or work, and, generally, will not take a portion of anything you recover. If you prefer to have an attorney represent you, but you are unable to pay to retain. 10. 1. You should consider contacting a local legal services office or state bar association. You may also call law firms and ask whether they have a pro bono practice and if you would qualify for such assistance. Appointment of counsel by the court. If your income, financial resources, or circumstances make it very hard for you to hire or otherwise find a lawyer, the court may find that you are indigent, which means that you do not have the resources to pay for an attorney. Typically, the court is asked to make this finding when a pro se litigant files a document with the court known as an application to proceed in forma pauperis. Information regarding the in forma pauperis application and the effects of being permitted to proceed in forma pauperis are discussed later in this handbook. If you are granted in forma pauperis status, you may request, by submitting a written motion, that the court appoint counsel for you if you are otherwise unable to obtain a lawyer. Before you submit such a motion, you must try to obtain counsel on your own. The court considers requests for counsel in light of a number of factors set forth by the district court's local rules. Usually, the court must determine whether the party's legal position in the lawsuit is of substance. If so, the court will then consider several other factors, including how complex the legal issues are in the particular case and the indigent party's ability to investigate and present his or her case. If you are granted permission to proceed in forma pauperis, and you decide to make a motion for the appointment of counsel, you must include with your motion details of your efforts to obtain counsel by means other than court appointment. In addition, you generally must include communications from the attorneys that you contacted regarding your case and what they indicated were their costs and/or other reasons for why you did not retain them. Failure to include. 11. Documentation that substantiates your attempts to obtain counsel on your own could result in the denial of your motion for appointment of counsel. 12. Before you bring a lawsuit, you should become familiar with the rules that explain the court's procedures for preparing and filing a complaint. These rules are the Federal Rules of Civil Procedure, FRCP, and they apply in every federal court in the country. A party can be sanctioned, penalties imposed. For violating the FRCP.3, you can review the FRCP in any law library or on the website for the district court where you will be filing your complaint. In addition, you must follow your particular district court's local rules, also found on the website for the district court where you are filing your complaint. 3.4. 1. Caption. 13. In the United States District Court. For the _____________ District of, State. Plaintiff's name. 1. City, State Zip Code, Case no ____________________________________________________________________________________________________________ Plaintiff versus complaint. Defendant number 1's name. 456th Street name. City, State Zip Code. Defendant number 2's name, if applicable. 789 Street name. City, State Zip Code. Defendants. You should list on page 1 of your complaint the name and address of the person filing the complaint, the plaintiff, and the names and addresses of all individuals or entities against whom you are seeking relief, the defendants. Point 4. For the name and address of each plaintiff and defendant may also be stated in numbered paragraphs in the complaint. In certain kinds of cases, the parties are entitled to a jury trial. The best way to ensure your right to a jury trial is to make the demand when you file your complaint by either writing the words jury trial demanded on the first page of your complaint or, if you are using a form complaint available from the clerk's office, by checking the option for a jury trial on the first page of the form complaint. 2. Body of the complaint. The body of the complaint should contain numbered paragraphs which provide the following information. A. Jurisdiction. The complaint should state why the court has jurisdiction over the case. As discussed previously, a district court has limited authority to hear cases. It can only hear cases over which the district court has jurisdiction. Pro se litigants often file the following types of federal cases: a denial of civil rights under 42 U.S.C. Section 1983, employment discrimination under 42 U.S.C. Section 2000E, etc. And inmates challenging the conditions of their confinement. The first numbered paragraphs should also state why the court you are filing in has proper venue for this claim. B. Number. Personally involved in and/or responsible for the alleged incident or harm may result in dismissal of that defendant or the case. In short, these numbered paragraphs must state the facts supporting the claim, what happened, where it happened, when it happened, how it happened, and who was involved. C. Legal basis. The complaint must also state the legal basis for the claim. This would be a description of how you believe the defendants violated your rights, and a statement of which of your legal rights you believe the defendants violated. If you are filing your lawsuit on the basis that the defendant violated a law, you must identify that law in your complaint. For example, if you believe an employer discriminated against you, you must cite to Title VII of the Civil Rights Act of 1964, as amended, 42 U.S.C. Sections 2000E, etc. D. E. Signature. The individuals filing the complaint must sign and date the complaint, and underneath the signatures, type or print their full names, addresses, and phone numbers. 5. If there is more than one plaintiff, the complaint must contain an original signature for each. 5. Your signature, address, and phone number must always appear on all documents filed with the court. Plaintiff. By signing or filing the complaint, you are certifying to the court that the statements you have made in the complaint are true, and that you are not filing the complaint for an improper purpose such as to harass the defendants. Privacy protection. Certain sensitive information about individuals involved in the claim cannot be included in documents filed with the court. If personal information is necessary for the complaint, personal identifiers must be redacted, blackened out, as follows. Minor children must not be identified by their full names, but by their initials, e.g., AB, CD. Financial account numbers must be redacted except for the last 4 digits, e.g., XXXXXXXX1234. Social Security and taxpayer identification numbers must be redacted except for the last 4 digits, e.g., XXXXX1234, and dates of birth must include the year only, e.g., X/X/1980. Filing the complaint. Once you have prepared the complaint, you must file the complaint in the district court clerk's office. The following procedures regarding copies of the complaint, filing fees, the civil cover sheet and the summons forms must be followed. 1. Copies. You must file the original complaint with the court and provide the court with a copy for each defendant you name. If the defendant is the United States, an agency of the United States, or an officer or employee of the United States who is being sued for acts or omissions related to his/her employment, you must provide the court 3 copies of the complaint. You should also keep a copy of the complaint for your own records. 17. 2. Filing fees. 6. 7. You should check the district court's website for further information concerning whether you can pay by cash, check, cashier's check, money order, or credit card. Generally, you must pay a filing fee when you file your complaint, and this fee must either be paid in full at the time you present your complaint to the court for filing or, if you are unable to pay the fee, you must submit an application to proceed in forma pauperis, along with your complaint, discussed below. The current filing fee for a complaint is $400, and payment is due when you file the complaint. 7. 3. Civil cover sheet. In addition to the complaint, you must also complete a civil cover sheet. This form is used to help the clerk's office open your case and gather statistical information. The form is also available on the district court's website or in the clerk's office. When you complete the form, you will need to include the county of residence of the first listed plaintiff and defendant. You will also need to identify the basis of jurisdiction. Federal question jurisdiction. The case involves a violation of federal law or the United States Constitution, and diversity jurisdiction. The plaintiff and defendant are citizens of different states and the case involves an amount of controversy greater than $75,000, are the two most common. Complete the form as best as you can. If you do not know how to provide some of the information required, then leave the space for that information blank. Note that the civil cover sheet contains instructions for completing the form on the second page. The district court's website will also provide the nature of suit codes to assist you in completing Section 4. 4. Summons. All plaintiffs must complete and submit a summons form for each defendant at the same time the complaint is filed. You need to prepare a summons for each defendant named in your lawsuit. The summons form is available on the district court's website or from the clerk's office. In completing this form, you must 1. Fill out the case caption, 2. Provide the name and address where the defendant is to be served with the complaint, and 3. Provide your name and address. Do not complete the proof of service portion of the summons form until service of process has been completed. 5. Filing. While you may be able to file your lawsuit in person with the clerk's office, most filing in federal court is done using an electronic system. The judge may order that you use this electronic system to understand what is happening with your case and to file documents. CM/ECF, Case Management/Electronic Case Files, is the name of this electronic system. Members of the public can gain access to this system using a system called PACER, Public Access to Court Electronic Records. You can contact your district court clerk's office to obtain information about how to use PACER to file documents, access documents filed by others, including orders of the judge, print, and download documents. Service of process. Service of process is the procedure that officially notifies a defendant in person that a lawsuit has been filed against him or her. When served, the defendant receives a copy of the complaint so that he/she knows what the lawsuit is about. Further, the summons, discussed above, notifies the defendant when they must respond to the complaint. Under Federal Rule of Civil Procedure 4, you must either obtain a waiver of service from each defendant or serve each. 19. Defendant through formal service or personal service within 90 days after the complaint has been filed in district court. Mailed summons are typically not allowed. 1. Waiver of service 8. 8. Waiving service means agreeing to give up the right to service in person and instead accepting service by mail. If a defendant waives service, the plaintiff, you, will not have to go to the trouble or expense of serving that defendant. If the defendant agrees to waive service, you need to have the defendant sign and send back to you a form called a waiver of service, which you then file with the court. To complete the waiver of service process, you must complete 2 forms and set certain documents to the defendants. The 2 forms you need to complete are: A. Notice of a lawsuit and request to waive services of summons. B. Waiver of service of summons. Both forms are available at the clerk's office or on the district court's website. The documents you need to send to each named defendant are: A copy of the complaint you filed. B. 1 completed notice of lawsuit form. C. 2 completed waiver forms, and D. 1 self-addressed stamped envelope for the defendant's return of the waiver forms. If a defendant sends back the signed waiver of service, you do not need to do anything else to serve the defendant. You simply need to file the defendant's signed waiver with the court and save a copy for your files. If the defendant does not return a signed waiver of service by the due date, you need to arrange to serve that defendant in one of the other ways approved by Federal Rule of Civil Procedure 4, see below. 2. Formal service, no waiver. If the defendant does not return the waiver of service form within the specified time, you must notify the clerk of the court in writing, prepare a summons for each defendant, and ask the clerk's office to issue the summonses you prepared. 9. You may ask the court to order the defendant to pay the costs you incurred serving that defendant. You must serve the defendant within 90 days from the filing date of the complaint, or, if you applied for IFP, from the date the court ruled on your IFP application. If you do not properly complete service of process within the 90-day deadline, your case may be dismissed. Be sure to carefully check the FRCP to make sure you properly serve the defendants you named in the complaint. 9. 3. Personal service. Service of process may be accomplished by personal service. This means that the summons and complaint are hand-delivered to the defendant. You, as the plaintiff, cannot personally serve the defendant. However, another person can personally serve the defendant if that person 1. Is at least 18 years of age and 2. Is not a plaintiff or defendant in the case. Alternatively, you can hire a private process server to serve the defendant for a fee. In either case, Federal Rule of Civil Procedure 4 requires you to file proof with the court that the complaint has been served on the defendant. The person serving the summons must leave a copy of both the summons form and the complaint with the defendant. On the back of the summons is a section referred to as the return of service or proof of service, which must be completed by the person who served the summons. The person who serves the summons must record his or her name, the name of the person whom he or she served, and the date and time of the service. Service of process is not complete until the original summons form, with the completed return of service, has been filed with the court. If the above service methods are not available, consult Federal Rule of Civil Procedure 4 and any local rule applicable for your district court. If you name as a defendant the United States, a United States agency, or an officer or employee of the United States, who is being sued for acts or omissions related to his/her employment, you must serve the complaint and summons on 3 individuals. 1. The named defendant. 2. 3. The United States Attorney for the district court in which you are filing your complaint. The waiver of service rule does not apply to the United States. Formal service upon the federal government or any of its agencies can be accomplished by certified mail, return receipt required, with the properly executed summons. Proceeding in forma pauperis, IFP. If you cannot afford to pay the filing fee, you may request to waive the fee by filing an application to proceed without paying fees or costs, or in forma pauperis. To apply for in forma pauperis status, you must present the following documents to the clerk's office. 1. Application to proceed in forma pauperis. 2. Civil cover sheet. 3. Original complaint with copies for service on each of the defendants. 4. All service forms, which includes the summons and U.S.M. 285 or waiver of service of summons, see below. You can obtain an in forma pauperis application on the district court's website or from the clerk's office. The in forma pauperis application asks you to provide information about your and your spouse's finances, e.g., your income, assets, and liabilities. In filling out the in forma pauperis application, you must answer all questions truthfully and completely. You must also sign the statement under penalty of perjury. In addition to waiving the obligation to pay the filing fee, if you are granted permission to proceed in forma pauperis, you are also entitled, 1. To submit a motion for appointment of counsel, and 2. To have your complaint served on the defendant by the U.S. Marshals Service. If your in forma pauperis application is approved, the court will arrange for the clerk's office or the U.S. Marshals Service to complete service of process on your behalf. In forma pauperis cases, the summons will not be issued until after the judge reviews the complaint. If the court determines, based upon the facts stated in your complaint, that you will not be successful in your case, e.g., you fail to state a claim upon which relief may be granted, your lawsuit is frivolous or malicious, or the named defendant is immune from liability, the court can dismiss your case at that stage. See 28 U.S.C. Section 1915 E2. Likewise, the court can dismiss your complaint at any time if you were granted IFP status and the court later determines that your allegation of poverty was untrue. However, if after conducting a preliminary review of the complaint, the judge finds that the complaint states a claim upon which relief may be granted, the judge will then order that a summons form be issued against the defendant. The judge will also appoint the clerk of court or the United States Marshal's Office to make service. In all instances, however, you are responsible. 23. For completing and providing the clerk's office with the appropriate service forms, this consists of the following service documents for each named defendant. 1. A copy of the complaint you filed for each defendant. 2. 1 summons for. 3. 1 U.S. Marshal form for each defendant. 10. 10. These forms can be found on the district court's website or obtained from the clerk's office. Once the forms are properly completed and filed, the clerk's office will officially issue the summons, e.g., an authorized court employee signs the form and embosses it with the court's official seal. The clerk's office will then deliver the summons and other materials to the U.S. Marshal Service, which will serve the defendant on your behalf. You will be notified when service has been accomplished. Defendant's response to the complaint. 1. Answer. If service is made on a defendant by summons, the defendant has 21 days from the date of service of the complaint to file an answer with the court. However, if the defendant is the United States or a federal official, the defendant has 60 days from the date of service to file an answer. In an answer, a defendant admits or denies each of the plaintiff's allegations. The answer can also include affirmative defenses. It is important that the defendant admit, deny, or clarify each allegation made by paragraph number. Once the defendant files an answer, the case moves to the next phase. 2. Default. If a defendant has been properly served with a complaint, but fails to file any response in the required amount of time, then that defendant is considered in default. Once the defendant is in default, the plaintiff can ask the court for a default judgment, which means that the plaintiff wins the case and may take steps to collect on the judgment against that defendant. If a defendant is in default, the plaintiff should file a request for clerk's entry of default and proof that the defendant has been served with the complaint. If the clerk of court approves the request, he or she will then enter default against the defendant. Once the clerk has entered default against the defendant, the plaintiff may then file a motion for default judgment supported by 1. A declaration showing that the defendant was served with the complaint but did not file a written response within the required time for responding, and 2. A declaration proving the amount of damages claimed in the complaint against the defendant. There are special rules for default judgments against minors and the U.S. government and its officers and agents, which are explained in Federal Rule of Civil Procedure 55. A defendant against whom default or a default judgment has been entered may make a motion to set aside the default or default judgment. The court will set aside an entry of default or a default judgment for good cause or for one of the reasons listed in Rule 60b, which includes mistake, fraud, newly discovered evidence, the judgment is void, or any other reason that justifies relief. 3. Motion to dismiss. In lieu of filing an answer to the complaint, a defendant may file a motion to dismiss, which asks the court to dismiss the case. The motion argues that there are problems with the way the complaint was written, filed, or served. A motion to dismiss may be filed for any of the reasons set forth in Federal Rule of Civil Procedure 12, be lack of subject matter jurisdiction, lack of personal jurisdiction, improper venue, insufficient process, insufficient service of process, failure. 25. To state a claim upon which relief can be granted, and failure to join a party under Rule 19. The motion to dismiss must state the specific facts and legal arguments supporting the stated reasons for dismissal. A defendant may move to dismiss all the claims in the complaint or just certain claims. A court may deny or grant the motion to dismiss as to each claim that is the subject of the motion. If the court denies the motion to dismiss, the defendant must file an answer within 14 days, and the case moves to the next phase. See Federal Rule of Civil Procedure 12a-4. If the court grants the motion to dismiss without prejudice, the plaintiff may submit an amended complaint that corrects the deficiencies identified by the court within a time period specified by the court. Finally, if the court grants the motion to dismiss with prejudice, the case is over as to those claims. A. Lack of subject matter jurisdiction. The defendant argues that the court does not have the legal authority to hear the kind of lawsuit the plaintiff filed. In other words, the defendant contests that the case neither involves a violation of a federal law or the U.S. Constitution, nor is between citizens of different states involving an amount in controversy greater than $75,000. B. A lack of personal jurisdiction. The defendant argues that the court has no legal authority to hear the case because the defendant has so little connection with the district in which the case was filed. The defendant must show that it is not a resident of the state in which the case was brought and that it did not even have minimum contacts with the state. C. Improper venue. The defendant argues that the lawsuit was filed in the wrong geographical location.
Now, remember, you watch some other videos, I've told you guys, you want to minimize your contacts with the police and with using public things, because the more you use the U.S. citizen stuff, the more they can say that you've had contacts with us. You've been playing the game. You're a part of us. You're rocking our colors, and our things are all registered, together in the U.S. citizen system. So you're one of us. So it can be like a catch-22. If you need to use it, it's there. But if you keep using it or using it a lot, then they can say, well, you're part of us. You must be. So you want to minimize using their stuff. This is some of the stuff that the founding fathers knew way back. They wanted you to stay private. But if you needed to use the system, that stuff, the public, which came along later on as a little Trojan horse, then yeah, you can use it, but you should be able to sell these things on your own. But when you can't, because some people are, evil or vindictive or whatever else, then you're going to be bringing your problems, your event, your scenarios to them to adjudicate or to judge. We're going to give you full jurisdiction to decide this between us, because they don't want you out there putting them pibbity paps on people and causing public controversy. So let's get back to it.
Location. 26. D. Insufficiency of service of process. The defendant argues that the plaintiff did not prepare the summons correctly or did not correctly serve the defendant. E. Failure to state a claim upon which relief can be granted. The defendant argues that even if everything in the complaint is true, the defendant did not violate the law. Each type of claim requires that the plaintiff allege and show facts to support certain elements. For example, a negligence claim requires that the plaintiff allege and show facts to support a duty, a breach of the duty, proximate cause, and damages. Here, the defendant is asserting that the plaintiff did not plead sufficient facts to support all requisite elements of the plaintiff's claim. F. Failure to join an indispensable party under Rule 19. The defendant argues that the plaintiff failed to sue someone who must be included in the lawsuit before the court can decide the issues raised in the complaint. A party must be included in a lawsuit when 1. A court cannot accord complete relief among the parties without the additional party's presence, or 2. The party's absence impedes its ability to protect its interest or leaves the party vulnerable to incurring inconsistent obligations because of the interest. See Federal Rule of Civil Procedure 19. Response to a motion to dismiss. If a defendant files a motion to dismiss, the plaintiff will need to file an opposition to that motion. The response must specifically assert facts and law that explain why the motion to dismiss should be denied. Any opposition to the motion to dismiss is typically due 14 days after the defendant files the motion. Check the local rules for deadlines specific to your district. To calculate the deadline, exclude the day that the defendant files the response, and 27. Beginning counting the next day. Count every day, including weekends and holidays. The response is due on the 14th, or 17th, if mailed, day, unless that day is a Saturday, Sunday, or legal holiday, in which case the response is due on the next day that is not a Saturday, Sunday, or legal holiday. See Federal Rule of Civil Procedure 6. If you need more time to file your opposition, you need to file a motion for extension of time with the court. If you can, contact the opposing side and get consent. If you get consent for an extension, make sure that consent is reflected in your motion. If you cannot get the consent from the other time, file the motion for extension of time before the response is due and show there is good cause for the extension. Federal Rule of Civil Procedure 6b. If a motion for extension of time is filed after the due date, you must show excusable neglect for missing the deadline. Federal Rule of Civil Procedure 6b. 28. Case Management Procedures. What is a case management, Rule 16, conference, CMC? A case management conference, CMC, sometimes referred to as a Rule 16 conference, is held shortly after the action commences. The purpose of the conference is for the judge and parties to set the trial date, as well as other key deadlines for initial disclosures, discovery, and pre-trial motions. Does every case have a case management conference? No, some categories of actions are exempt from CMCs. Refer to the local rules for your district. How do I prepare for it? Rule 26. At least 21 days before the CMC, all parties and their lawyers must meet and confer either on the phone or in person, to try to agree on a number of issues. The purpose of the meet and confer process is to save time by requiring parties to agree on as much as possible and to understand each other's positions. The parties should be prepared to 1. Discuss the basis of the claims and defenses. 2. Discuss resole. 3. Arrange for the initial disclosure of information by both sides as required by Rule 26a(1), including a. An exchange of names and contact information of individuals with discoverable information, and b. A list of certain documents described in FRCP 26a. 4. Agree on a discovery plan. 5. Select an alternative dispute resolution (ADR) process, mediation, early neutral evaluation or settlement conference, discussed later in this handbook. 6. Prepare and file a joint written report outlining the discovery plan. Preparing the discovery plan, Rule 26(f)(2). The proposed discovery plan is a written proposal on how the parties expect to conduct discovery, i.e., a schedule of when and how the parties will exchange documents and conduct depositions in order to learn the facts of the case. The parties must make a good faith effort to agree on a proposed discovery plan for the judge to review and determine how discovery should proceed. The plan should include each party's views and proposals about 1. Changes that should be made in the timing, form, or content of disclosures under Rule 26a, including a statement of when initial disclosures were made or will be made. 2. The subjects, timing. 3. Limitations on discovery imposed by federal or local rules. 4. Other orders that the court should consider under Rule 26c or under Rule 16b or c. What is the case management order? During or after the CMC, the judge will issue a case management order, which sets the schedule for the rest of the case. The case management order will govern the case unless and until it is changed later by the judge. A case management order shall not be modified except upon a showing of good cause and by leave of the district judge. Federal Rule of Civil Procedure 16b. If you want to change the deadline set forth in the case management order, you will need to file a motion requesting that the deadlines be changed and show good cause for the request. What happens at a court hearing? A hearing is a formal court proceeding in which the parties present their arguments to the judge and answer the judge's questions about the motion or other matter being heard. Sometimes witnesses can be presented at these hearings. You should prepare for a hearing by reviewing all papers that have been filed for the hearing and expect to answer questions about issues that are being addressed at the hearing. Organize your papers so that you can find things easily when you need to answer the judge's questions. Be sure to have a pen and paper with you so that you can take notes. How should I dress and behave when I come to court? 1. Dress nicely and conservatively. Point 2. Be on time. Point 3. You should sit in the benches in the back of the courtroom until your case is announced. The courtroom deputy may ask counsel to come forward and check in. You should check in with the courtroom deputy at that time. If your hearing is the only one scheduled, you may sit at the plaintiff's or defendant's table in the center of the courtroom. The courtroom deputy will tell you where to sit. Point 4. When the judge enters the courtroom, you must stand and remain standing until the judge sits down. Point 5. When you speak to the judge, call him or her your honor. 6. A judge might ask you questions about your argument in a motion. If the judge asks a question, always stop your argument and answer the judge's question completely. When you are finished answering the question, you can go back and finish the other points you wanted to make. Always answer the judge's questions completely and never interrupt the judge when he or she is speaking. 7. If the judge asks you a question when you are seated at the table or away from the lectern, stand and walk up to the lectern before you answer the question. 31. Discovery. Discovery is a term that refers to the information that the parties will gather to support their case. Federal Rules of Civil Procedure 26 through 37 govern discovery. Parties often need to gather documents such as medical records, employment records, or business records. Information can be obtained in the form of written questions, written document requests, or oral questions. Discovery can begin only after the parties have met and conferred. Rule 26(d). Earlier discovery can take place if the parties agree or if the court issues an order allowing earlier discovery. Each party in an action will seek some discovery. This means that if you file an action, you will need to obtain information from the party you are suing, as well as provide information to that party. For example, if you file a personal injury action, your medical condition is at issue and you will need to provide some of your own medical records to the opposing party. Methods of discovery available. Interrogatories, requests for production, depositions, requests for admissions, and a mental or physical examination are the most common methods for obtaining discovery. You will need to read the federal rules carefully regarding each type of discovery request to make sure that you comply with their specific requirements. This handbook will give you a quick overview of the methods of discovery and how they may be useful to your case. 1. Interrogatories, Rule 33. Interrogatories are written questions sent by one party to any other party to the lawsuit and must be answered in writing and under oath. Rule 33 of the Federal Rules of Civil Procedure covers interrogatories in detail. If you are serving interrogatories, you may not serve more than 25 interrogatories without the court's permission. 32. If you are answering interrogatories, you must answer any interrogatory with all non-privileged information available to you without doing research. This means that if the answer is contained in your business records or personal files, you must look for the answer. You may object to an interrogatory seeking privileged information or that is overbroad, vague, or unduly burdensome. You must explain fully the reason for your objection. If you later learn that your answer is incomplete or incorrect, you must let the other side know and promptly supplement your original answer. The interrogatories must be answered within 30 days and must be signed in accordance with Rule 26(g)(1). If you need more time to answer, you can request more time from the opposing party. If the opposing party does not agree, you can request more time from the court by filing a motion. 2. Requests for production, Rule 34. In a request for production of documents, you can ask the opposing party for documents, including electronically stored information, like emails, which you need to make or defend your case. You may seek documents that you reasonably believe the other side has and contains information relevant to the lawsuit. If the person who has the documents you want is a party to the lawsuit, you must follow Rules 34A and B. Under Rule 34A, any party can serve another party: 1. A request for production of documents, 2. A request for production of tangible things, or 3. A request for inspection of property. Each request for document production should be numbered separately and signed in accordance with Rule 26G1. There is no limit to the number of requests, as long as they are not unreasonable or unduly burdensome. 33. If you have been served with a request for production of documents, you must give a response within 30 days, unless you obtain an extension from the opposing party or the court. If you object to a request, you must state the reason for the objection. Rules 34C and 45 cover obtaining documents from persons not party to the lawsuit. Under Rule 34C, you can ask the court to compel a person who is not a party to the lawsuit to produce documents and items or submit to an inspection. 3. Depositions, Rule 30. Depositions are question and answer sessions that takes place outside the hearing of the court, but are recorded by a court reporter. The person being deposed is under oath, the deponent, and that person may be a party, non-party eyewitness, or expert witness. The deponent answers all questions under oath, meaning that he or she swears that his or her answers are true. The party seeking to take a deposition should confer with opposing counsel and the deponent to choose a convenient time and place for the deposition. The party asking for the deposition must then prepare a notice of deposition and serve the notice on all parties. Point 11. You may ask questions of the deponent about any non-privileged matter that is relevant to the claims or defenses of any party. The party taking the deposition must pay the cost of the court reporter. After the deposition, the parties must obtain a copy of the transcript from the court reporter themselves. 11. Specific instructions for a notice of deposition is contained in Federal Rule of Civil Procedure 30B. 4. In a request for admissions, one party can ask the other party to admit the truthfulness of facts related to the lawsuit. The court will consider anything admitted in response to a request for admission as proven. Requests for admission may be served by any of the methods listed in Rule 5b of the Federal Rules of Civil Procedure, including service by mail. If you are responding to a request for admissions, you must admit or deny the request or explain in detail why you cannot truthfully admit or deny it. If you do not know the answer, then you must state that you do not have enough information to admit or deny the request, but you must first make a reasonable search for the information. Remember, any matter that is admitted is treated as a proven fact within the context of this particular lawsuit. 5. Mental or physical examinations, Rule 35. When the mental or physical condition of a party, or a person under the custody or legal control of a party, is at issue in a lawsuit, Rule 35 of the Federal Rules of Civil Procedure allows the court to order that person to submit to a physical or mental examination. The examination must be done by a suitably licensed or certified examiner, and the party who requested the examination must pay the examiner. The examiner is not responsible for treating the person, and any communications with the examiner are not confidential. Unlike other discovery procedures, physical or mental examinations can be obtained only by filing a motion with the court or by agreement of the parties. Discovery disputes. Sometimes, the parties will disagree about the disclosures, discovery, or objections filed. The federal rules require the parties to meet and confer to try to resolve the dispute before filing a motion to compel with the court. Under Rule 37A(2), a motion to compel a party to make disclosures or to respond to discovery must be filed in the court where the lawsuit is pending. A motion to compel must include 1. A certification that have tried in good faith to resolve the problem without help from the court, and 35. 2. An explanation of the problem and what you want the court to do, and 3. If the problem involves discovery, the complete text of each disputed discovery request immediately followed by the complete text of the objections or disputed responses to that request, and 4. An explanation of the facts and law that make it appropriate for the court to grant your motion. 36. Alternative dispute resolution. What is alternative dispute resolution? Alternative dispute resolution, ADR, can save time and money by helping parties work out their differences without formal litigation. ADR can lead to resolutions that are better tailored to the parties' interests. Methods include mediation, arbitration, and settlement, among others. In many courts, the parties are required to participate in some form of ADR before trial, and such requirements will generally be included in the case management order. What are the major ADR processes? 1. Settlement conference. In some jurisdictions, a settlement conference may be available to the parties. In a settlement conference, a judge other than the assigned judge, usually a magistrate judge, helps the parties negotiate a settlement of all or part of the dispute. Settlement conferences are generally best fit for pro-se litigants because a judge who has experience working with unrepresented parties conducts the process. 2. Mediation. In mediation, a neutral third party meets with the parties to help them negotiate a mutually satisfactory agreement resolving all or part of the dispute. The process is informal and confidential. Any decision to enter into a settlement agreement is voluntary, and the parties do not lose their right to trial if they do not reach an agreement. 3. Arbitration. In arbitration, the parties submit their dispute to an arbitrator or a panel of arbitrators for review, hearing, and adjudication in a binding decision. Arbitration is similar to litigation because both parties present arguments and evidence, including witnesses, to a neutral decision-maker. 37. Arbitration is an abbreviated, efficient means of resolving disputes, the outcome of which contractually has the force of a mandatory, binding determination. 4. Early neutral evaluation. In early neutral evaluation, ENE, a specially trained lawyer who is an expert in the subject matter of the case gives the parties a non-binding assessment of the merits and may help with settlement discussions. The goals are to promote communication and provide a reality check about the claims and evidence, identify and clarity key issues in dispute, assist with discovery and information exchange and motion planning, and help with settlement discussions if requested by the parties. 5. Limited scope ADR counsel, if available in your district. Most cases are referred by the court to go to ADR. In some jurisdictions, if you do not have a lawyer, you may request that the court appoint a lawyer to you for the limited purpose of representing you at mediation. Although the scope of this representation is limited, the lawyer can engage in settlement discussions with the other side, request additional discovery that would assist in the mediation, and meet with you to prepare for your mediation. Please refer to local rules for more information on ADR in this court. 38. Motions for summary judgment, Rule 56. A motion for summary judgment asks the court to decide a lawsuit without going to trial because there are no disputes about the key facts of the case. When the parties agree on the facts, or if one party does not have enough evidence to support his or her case, the court can decide the issues based on the papers that are filed by the parties. When the plaintiff files a motion for summary judgment, the goal is to show that the undisputed facts prove that the defendant violated the law. When defendants file a motion for summary judgment, the goal is to show that the undisputed facts prove that they did not violate the law. The overwhelming majority of summary judgment motions are filed by defendants. Sometimes, a motion for summary judgment can address the whole lawsuit or individual claims. If the summary judgment motion addresses the whole lawsuit and the court grants summary judgment, the lawsuit is over. If the court denies a motion for summary judgment, it means that there is a dispute of material fact, and the case will go to trial unless the parties settle. A motion for summary judgment must include a statement of undisputed facts. Each fact must be supported by admissible evidence, such as deposition testimony, affidavits, or relevant documents. If you need specific discovery in order to provide more evidence to the court showing why summary judgment should not be granted, you can file, on or before the deadline for opposing the motion, a request under Rule 56D of the Federal Rules of Civil Procedure for additional time to conduct discovery. Your request must be accompanied by an affidavit or declaration clearly setting out 1. The reasons why you do not already have the evidence you need to defeat summary judgment, and 2. Exactly what additional discovery you need and how it relates to the pending motion for summary judgment. 39. Trial. If a case has not settled or been dismissed following a motion for summary judgment, it is going to trial. You have to make pre-trial disclosures to the other party before trial, including expert witnesses and reports and witness and exhibit lists. Read Rule 26A(2) and A(3) for more detailed information. The following information is not meant to be all-inclusive, and you should always consult the Federal Rules of Civil Procedure and the local rules to make sure you understand what the court requires of the parties preparing for trial. You should also become familiar with the Federal Rules of Evidence, which govern the admission of evidence at trial. 1. Final Pre-Trial Conference. Prior to the actual trial, a pre-trial conference is usually held between the judge and the parties, or their counsel, to determine 1. What exhibits and witnesses each side might use during the trial, 2. The approximate length of time that will be necessary for the trial, and 3. The ground rules the court will utilize before, during, and after the trial. 2. Motions in limine. Parties may argue motions in limine at the pre-trial conference. These motions request that the judge not allow certain facts to be admitted into evidence, such as insurance policies, criminal records, or other matters which are either not relevant to the particular case or which might unfairly influence the jury. Either party may file a motion in limine. 3. The role of the judge and jury. If your case proceeds to trial, the parties will each get the opportunity to present their side of the case, and the judge and jury, if the trial is a jury trial, are responsible for entering a verdict and judgment based on the evidence and arguments presented. It is the judge's duty to see that only proper evidence and arguments are presented. In a jury trial, the judge also instructs the jury. 40. Which will be called upon at the conclusion of the jury trial to make decisions regarding factual matters in dispute. A judgment will then be entered based on the verdict reached by the jury. If the parties have not requested a trial by jury, the judge becomes the trier of both law and fact. At the end of the trial, the judge enters findings of fact and conclusions of law, sometimes in writing, based on the evidence and arguments presented. A judgment is then entered based on those findings of fact and conclusions of law. A jury trial begins with the judge choosing prospective jurors to be called for voir dire examination. The court will determine the number of jurors. Peremptory challenges. Each party will be given a number of peremptory challenges which enable the party to reject, in most cases, prospective jurors without cause. This decision is based on subjective considerations of the party when he or she feels a prospective juror would be detrimental to his or her case. Challenges for cause. The plaintiff or defendant may also challenge a prospective juror for cause when the prospective juror lacks a qualification required by law, is not impartial, is related to either of the parties, or will not accept the law as given to him or her by the court. For opening statements. After the jury is sworn in or impaneled, each side may present an opening statement. The plaintiff has the burden of proving that he or she was wronged and suffered damages from that wrong and that the defendant caused those damages. The plaintiff is allowed to present the opening statement first. This may be followed by a statement by the defendant. The court will determine the time to be allotted for opening and closing arguments. 5. Testimony of witnesses. After opening statements are given, testimony of witnesses and documents are presented. 41. To the jury or the court. The plaintiff presents his or her case first. After the initial examination of a witness, also known as direct examination, cross-examination is conducted by the other side. After a party has cross-examined a witness, the opposing side has the opportunity to conduct redirect examination in order to re-question the witness on the points covered by the cross-examination. If a witness testifies as to a fact, and a statement or document in the case file contradicts that testimony, the document can then be used to question the witness on the accuracy of the witness statements. If the evidence shows that the testimony of the witness is false, the witness is considered impeached by the cross-examination. 6. Motions during the course of the trial. Motion for judgment as a matter of law. This motion is usually made by the defendant at the close of evidence presented by the plaintiff. It is based on the premise that the plaintiff has failed to prove his or her case. If this motion is granted, the trial is concluded in the movant's favor. If the court denies the motion, the trial continues with presentation of the defendant's side. Motion for mistrial. Either party can move for a mistrial if, for example, during the course of the trial certain matters which are not admissible, such as those determined to be inadmissible in a prior motion in limine, are presented by any witness either purposely or unintentionally, in the presence of the jury. If the judge grants the motion for mistrial, the trial is immediately ended and the jury is dismissed. Objections. During the examination of a witness, one side may object to the questioning or testimony of a witness, or presentation of evidence, if the litigant believes that the testimony or evidence about to be given should be excluded. If the objection is sustained by the judge, that particular testimony or evidence is excluded. If the objection is overruled by the judge, the 42. Testimony or evidence may be given despite the objection. Check the Federal Rules of Evidence to make sure you know the proper grounds for making an objection. 7. Closing arguments. Closing arguments to the jury set out the facts that each side has presented and the reasons why each party believes the jury should find in favor of him or her. Time limits are sometimes set by the court for closing arguments, and each side must adhere to the specified time. 8. Charge to the jury. After each side presents testimony and evidence, the judge delivers the charge to the jury, usually in the form of written instructions. Each side may present proposed written instructions to the judge for consideration. After the judge has considered all proposed instructions, the jury is given appropriate instructions which set forth the jury's responsibility to decide the facts in light of the applicable rules of law. The jury then returns a verdict in favor of either the plaintiff or the defendant and assesses damages to be awarded, if any. 9. Judgment. Following the entry of the jury's verdict, judgment in favor of the prevailing party is entered by the clerk. If costs are awarded to the prevailing party, it is necessary to prepare a bill of costs for the approval of the court. A bill of costs sets forth those costs that were incurred in the suit. A prevailing party may serve a bill of costs within 30 days after entry of a judgment. If attorney's fees are awarded, an application for attorney's fees must be made by motion filed no later than 14 days after entry of judgment. See Federal R. Civ AP 54 D 2. Appeal. If you are unhappy with the ultimate disposition of your action, you may appeal that determination to the United States Court of Appeals. Grounds for an appeal usually consist of 43. Allegations that the judge made an error either in interpreting or applying the law or in a procedural ruling during the course of the case. Any error must have been sufficiently significant that the judge or jury reached an incorrect result because of the error. In general, only final orders or judgments of the district court may be appealed. 28 U.S.C. Section 1291. This kind of appeal is called an appeal as of right. Most orders issued before judgment, interlocutory orders, cannot be appealed until a final judgment is entered. Some of the few interlocutory orders that can be appealed are listed under 28 U.S.C. Section 1292. A final order or judgment is the document which announces the final decision with respect to your case, that is, whether you won or lost, and closes the case with the district court. In order to appeal, a final order or judgment should be entered on the docket of your case. Timing. An appeal must be filed within 30 days after entry of judgment or order being appealed. Exceptions to this rule are few. If you plan to. Glossary of Common Legal Terms 12. This glossary was borrowed from the United States District Court for the Northern District of California's Handbook titled Representing Yourself in Federal Court, a handbook for pro se litigants, drafted by Susan Y. Sung, Clerk of Court, 2017 edition. Action, another term for lawsuit or case. Admissible evidence, evidence that can properly be introduced at trial for the judge or jury to consider in reaching a decision. The federal rules of evidence govern the admissibility of evidence in federal court. ADR, Alternative Dispute Resolution, a court-sponsored program offering methods by which a complaint can be resolved outside of traditional court proceedings. Adjourn, adjournment, to bring a proceeding to an end, such as a court calendar or trial. Affidavit, a statement of fact written by a witness, which the witness affirms to be true before a notary public. Affirmative defenses, allegations included in the answer that, under legal rules, defeat all or a portion of the plaintiff's claim. Allegation, an assertion of fact in a complaint or other pleading. Amend, a document to alter or change a document that has been filed with the court, such as a complaint or answer, by filing and serving a revised version of that document. Certain documents cannot be amended without prior approval of the court. Amended pleading, complaint or answer, a revised version of the original complaint or answer that has been filed with the court. Amount in controversy, the dollar value of how much the plaintiff is asking for in the complaint. Answer, the written response to a complaint. An answer on the merits challenges the complaint's factual accuracy. Appeal, to seek formal review of a district court judgment by the Court of Appeals. Application to proceed in forma pauperis, IFP, a form filed by the plaintiff asking permission to file the complaint without paying the entire filing fee at the start of the case, but instead to pay in installments. The plaintiff must establish an inability to pay the whole fee. Arbitration, a form of alternative dispute resolution, overseen by a judge or arbitrator, in which the parties argue their positions in a trial-like setting that lacks some of the formalities of a full trial. Arbitrator, the neutral third party who presides at arbitration, usually an attorney. Award, the sum of money or other relief to which an arbitrator rules the winning party in an arbitration is entitled. Bench trial, a trial in which the judge, rather than the jury, determines the law, the facts, and the verdict of the lawsuit.
All right. So that is it. You now have a basic foundation. I'm not going to let the video continue to just read all the definitions. You guys can do that on your own. I'm not going to bore you guys to tears. A majority of that I already knew. There was one or two new things that I learned in listening to this, so that was good. Some of the terms that were mentioned, you guys should read through those on your own time and get familiar. That being the case, guys, that is it. I want to thank you guys for watching the video. As always, feel free to hit that bell, like, and subscribe, and to share the video or to repost it. Hopefully it was informative. Most of you hopefully will not need this information, but if and or when you do, you now know how to move. All right, guys, that is it. I got some more videos to make, and I am going to take a break just for a minute, then I'll be right back. So I'll talk to you guys later. Enjoy your day, and reduce your contact. Minimal contact. Minimal contacts is key. Stay in the private as much as possible, guys, and I'll talk to you later.